Right, so we'll get started. Um, so thank you everyone for joining us today. I'm Sharon Campo, Supervising Attorney of Volunteers and Community Projects here at Legal Services of Long Island. I am the Supervising Attorney at the Legal Support Center for Advocates. And today we have with us Supervising Attorney Larry Tuthill, who will be reviewing the topic Understanding the Family Law Legal Process Involving Victims of Domestic Violence. And we're just going to review that and also what we're doing now in Nassau County. Very exciting. But just a few housekeeping. Please keep your microphone muted just so we don't have any background noise. I'd really appreciate it. I am going to kick out, I just saw a note taker. I'm going to kick out any note takers. I'm sorry about that, but I just don't like to have AI in the meetings. So I'm going to remove any AI I see in the meeting. But if you do have questions, you can put them into the chat and we will answer the questions throughout the presentation. Please try to keep it to not very personal questions. If there's any personal questions, you can always email me afterwards and I can pass it along. But anything that's general, please put the questions in the chat and we will answer throughout. We'll just have a few polls throughout the presentation, and at the end we have a survey. If you could please complete that, we do take a look at those, and for feedback and also to get ideas on other presentations we can give to you all. So if you're unfamiliar with Legal Services of Long Island, we are Long Island's largest provider of free civil legal services. We handle over 6,000 cases every year, including direct representation, phone consultations, brief service, and referrals. We have offices in Hempstead, Islandia, and Riverhead, and our case handling staff includes attorneys, paralegals, and social workers. We do have partnerships with community agencies, whether it's Brighter Tomorrows or Empire Justice or other entities. We have 3 different offices in Hempstead, Islandia, and Riverhead. Any clients who are looking for legal services to be screened, please call one of those phone numbers. You can also walk in as well. We have about 20 different units in different areas of law. It could be family, such as what we're going to be discussing today, the Domestic Violence Family Court Project, or it could be a disability and health related project, whether it's our mental health unit or our disability advocacy project. In addition, we have our housing units all over the Long Island, whether it's our civil unit, which assists with eviction prevention, or a foreclosure project in other different areas, whether it's assisting veterans, helping with public benefits, or consumer debt, which is what I supervise here in Suffolk. And our Legal Support Center for Advocates is specifically for advocates who maybe work for, let's say, an elected official's office or a social agency, or perhaps you're a volunteer for a church. So if you have a client who's going through a legal issue and you have a question or you want to see if it's something that we would assist with, please give us a call. That way you're not making a dead referral to us. So you can call either myself, Kathy, or Hannah, and we'll see if we can, either get you a referral or let you know what, if we can provide that service or any legal information we can provide to you. We also host the trainings like we do today, and we publish newsletters. We just published a recent newsletter as well. So I'm going to be sending that out via email soon. Okay, so just quick polls here, just to get an idea of who we have with us today. So what type of advocate are you? If you could just check off, you can check off more than one. I also added a box here if you work with victims of domestic violence, so just so we have an idea of who is with us today for Larry. So that way we just have an idea. So if you can take a moment to answer that, we'd really appreciate it. Okay, just a few more seconds. Okay, we'll just share the results. So we have a few social workers with us, a lot of attorneys, a good chunk of nonprofit employees, government agencies, church volunteers, self-advocates, and a lot of folks who work with victims of domestic violence. So thank you so much for sharing that with us. And the next question we have is, have you ever called the Legal Support Center for Advocates? Let me just grab that. So if you could just let us know if you are a regular, you call once in a while, or this is the first time you're hearing about it. Okay, just a few more seconds. Okay, still some folks answering. Thank you so much. All right, so I'm going to end the poll and let's take a look. Okay, so we have about half of you have never heard about the program, so welcome, and we hope that you're able to use our service. And we have a bunch of folks who have already used our service. So thanks so much for joining us today. Okay. So, and then of course we have our website for anyone who hasn't been on there yet. If you ever, you can also look on our website for descriptions of all of our programs, to sign up for our emails when I send out advocacy tips and our newsletters, and also alerts on our trainings. We have self-help resources on there as well for folks, and other events that are coming up. And just a note that Legal Services of Long Island makes every effort to keep our legal educational materials up to date. And the information contained in the material presented today is not legal advice. Legal advice depends on the facts of each situation, and the materials we're providing cannot replace the advice of competent legal counsel. And with that, I'm going to pass it along to Larry Tuthill, our supervising attorney for the Domestic Violence Project, and take it away.
Good afternoon, everybody. As Sharon said, I'm Larry Tuthill. I'm the domestic supervisor for domestic violence, and I've been doing that for many years in Suffolk County. We've been representing victims of domestic violence for a while now, and we get most of our referrals from Retreat and Brighter Tomorrows. We have a relationship with both those agencies, but we also accept referrals from other domestic violence agencies. We have just expanded our domestic violence unit in Nassau. As many of you know, the Safe Center is no longer with us, and they represented victims of domestic violence in family court in Nassau County. So we have expanded our team, and we are also representing and I'm sorry, and always have the undocumented. And we continue to do that in Nassau County. However, in Nassau County, we will also be representing the undocumented with some of their immigration issues. And it's just something that we started. We're not experts in it yet. We just hired an outside immigration attorney to not only help us with the cases, but also train us to do that. And so right now, I'd just like to introduce our team. If they could pop on the screen, we have two very experienced attorneys, Victoria Roman and Regina Conroy. They're experienced in family court. They're experienced in representing victims of domestic violence. And we add to that Arlene Lopez and Ishrat Jahan. They are newer attorneys, but they are assisting, representing clients in court. And of course, our we have an excellent paralegal, Fanny Brooks. She is assisting all of us in representing clients. Arlene, Victoria, and Fanny are all fluent in Spanish. And the five of us are, or six of us, I'm sorry, are representing people in Nassau Family Court. I'd just like to ask Arlene just to give a brief 2-minute talk on what we do with regard to immigration. It's basically U visas. I don't want to take questions on immigration right now because this is basically toward domestic violence. But I do also want to alert people to what we're doing here. Arlene.
Sure. Hi, everyone. So my name, as Larry said, is Arlene Lopez. I'm a staff attorney here at Legal Services in the Domestic Violence Unit. And as you mentioned, we also do some work on immigration through the U visas. We know that many survivors of domestic violence, they face a really difficult choice, especially if undocumented. It's this idea of either stay silent or risk deportation if they report abuse. And so this U visa basically exists to help address that barrier. It's a form of immigration relief for victims of certain crimes. It includes domestic violence, and for people who've been helpful or are willing to be helpful to law enforcement. It provides temporary legal status, work authorization, and a pathway to lawful permanent residency. For survivors, this can be absolutely life-changing. It creates a pathway to seek help, to pursue justice, and engage with the legal system with greater protection from immigration consequences. And at the same time, many survivors, they still have very real fears about interacting with law enforcement, which we're extremely mindful of in our work. So at Legal Services, we've recently begun offering these U visa services as part of our DV work. We screen clients for eligibility, we prepare and we file petitions, we assist with work authorization, we work with the law enforcement to obtain the supplemental certifications needed in the applications. And as Larry said, our team combines in-house attorneys with some experience in immigration counsel, as well as with an experienced immigration counsel, and which allows us to provide both really direct support and also like specialized expertise. So if you're working with a survivor who may benefit from this type of relief, we would of course be happy to connect after this training.
Thank you, Arlene. And as everyone is aware, this is very scary times for the undocumented here. I represented a victim in family court here in Suffolk County, and she wasn't being paid her child support by the abuser. And I explained to her, if we go for incarceration because we knew he had the money, he risked being deported. And we brought the proceeding. We gave him time to pay. He didn't, and eventually he was incarcerated. He owed about 30 grand. And the family of the abuser, the father, they came up with the 30 grand. My client got the 30 grand, and he did that obviously to get out of jail. But unfortunately, he didn't. There was an ICE hold, and he was deported. And obviously, it doesn't help my client because he's not. I don't think he's going to pay from the country where he was deported to. So there are a lot of issues that we're dealing here with the undocumented. We've always represented the undocumented in family court for victims of domestic violence, and we will continue to with regard to Suffolk and Nassau. So with regard to our services, we represent clients in family court. We do not do divorces. And as I'm sure many of you are aware, it's very time consuming. And there aren't many people who, even regardless of whether they're victims of domestic violence, will handle divorces for free. What we do, like I said, in family court, the first thing we do is try to assist victims in getting an order of protection. And a lot of times they go in and they seek the order of protection in family court by themselves, and then we would represent them after. And there are two types of orders of protection. They are refrain from and stay away. And the order of protection, as many of you recognize, is also a piece of paper. But if it's violated, there are pro-arrest policies, and the abuser is arrested for violating it. And as I said, there are two orders of protection. There's a refrain from order of protection. And that basically says you can't commit a crime against the victim. Well, of course, you're not allowed to anyway. But as I said, there is the pro-arrest policy, and people do get the refrain from orders of protection. They also get stay-away orders of protection, and that's where they must stay away from the person, stay away from the home, stay away from the place of the employment. And there are carve-out exceptions with regard to seeing the children or curbside drop off and pickup. And what happens is they get their temporary order protection ex parte. That means by themselves when they go into court. And then that order protection is served on the abuser and given a court date as to when to come to court. And that first date is a conference. And there we're determine whether the abuser will consent to the order of protection, whether they want a hearing, whether they want an attorney. And it's so we will represent the clients through this entire process, and we will also assist them with regard to violation petitions. As you are aware, in family court, there has to be a family court, or I'm sorry, a family relationship. All right, they need to be related in some way, shape, or form, or they must be related through blood, or have an intimate relationship. And yeah, Sharon, this is on the next page. And an intimate relationship does not have to be sexual, but there has to be some relationship for you to be in family court. And could be having a child together, could be mother-daughter, could be cousins, anything like that. And that's where the family court jurisdiction, that's where the family court obtains their jurisdiction. If there is no relationship, they would go to criminal court. And that's where, when a crime is committed against somebody, the abuser is arrested, and the district court judges will generally issue an order of protection. And here, no family relationship is needed. Our clients who are in family court are also entitled to get an order of protection in criminal court. You can have two. And it is easier to get a family court order of protection because you only have to prove your case by a preponderance of the evidence. In criminal court, as you all know, you have to prove your case beyond a reasonable doubt. And so that's why it is more difficult to get an order of protection in criminal court. And we do not represent victims in criminal court because they're represented by the district attorney. The district attorney is prosecuting the case, and they, line up their witnesses. They will be representing the victim at the trial. In family court, that's where we represent the clients. And as I said, the respondent is entitled to an attorney. If they can't afford one will be provided for them by either legal aid or what they call an 18B attorney. That's somebody who's representing the abuser, and they don't have to pay. But again, they would have to be income eligible to get a free attorney. We also have income guidelines, and that's 200% of the poverty, and that's a federal guideline. And when you refer a case for a victim of domestic violence, we also have to do a conflict check because, as Sharon pointed out, we represent a number of people throughout Long Island in a whole bunch of different issues. And as attorneys, we cannot represent an ex-client, against them, because obviously we would have information, particularly if, they were with us through Social Security and we were representing them it'd be a foreclosure of victims, because we would have information with regard to what their financial status is, what money they might have, and other information. So when you refer a case, just please recognize that we will have to do a conflict check. And what the victim has to do to get an order of protection, and a lot of times they do this on their own, and that's fill out a family offense petition. If it is deficient, many times we ask the judges and are allowed to make an amended petition. In other words, we allege other incidences, and sometimes a victim will forget or not remember certain cases. We generally like to go back within the last year, but as I'm sure many of you realize, there are many serious incidences that happened years ago, and it has stopped, and now it's escalating again. And so you can put incidences that have happened in your petition. And in the petition, you're just asking the judge for an order of protection. You can sign that confidentiality affidavit, so you don't let the abuser know where you live. And obviously, this is in times where the abuser has gone to a domestic violence shelter. And I know the Brian Tomorrow's is now running, taking over the Safe Centers shelter. And so there is one at least one in Nassau County. In the petition, you say what happened. You want the court to get jurisdiction, and you say the relationship between you and the abuser. You describe all the events. We like to tell a story, but we also want to make it very clear what the worst event is, and also the most recent event, because the most recent event is what brings the victim to court. It could be the final straw, it could be the most serious. Many times it's not the most serious, but it seems to be, the abuse seems to be escalating. And you tell the judge what you want. Do you want to refrain from order protection? Do you want a stay away order protection? Do you want to add clauses in there that prevents communication? And we have seen many times that the courts will put in there that the abuser cannot be under the influence of drugs or alcohol or be in possession of. And as I'm, it's, we deal with all different issues in family court, mental health, addiction to drugs and alcohol. We also represent people, with regard to neglects. A lot of times the neglects are brought against the abuser, and then we represent the victim as a non-respondent with regard to the neglect. And so what I'm informing of is just that we deal with all the different social issues that are in our society, and they are all dealt with in family court also, because they either contribute and or exacerbate the domestic violence. And our goal here at Legal Services of Long Island in the Domestic Violence Unit is to get the victim away from the abuser, deal with the custody issues if there are children, and also deal with support. And when I mean support, I mean spousal support and child support. That's to get the abuser away from the victim, get the victim set up. There are organizations out there that can assist with housing. And we work with all these different organizations, and everything is done in-house, generally by one attorney. One attorney will just work with them through the entire process. And as I said, with regard to the temporary order of protection, once that's issued, they come back to court, and the abuser then will be there on the court on that day, and then we'll determine if they have or want an attorney, and then we'll represent them at the trial if there is such a trial date. We also will represent them in violation petitions. Now, if somebody violates an order of protection, we certainly tell our clients, you call the police, and the clients will arrest, and they are charged with a crime over in criminal court, and generally issued another order of protection if there is not one in criminal court. You are also entitled to bring a violation petition in family court. And you can incarcerate, in family court, but that's generally the reason for the violation petition is to make sure you get your order of protection if they are challenging it initially, because even if an order of protection is found not to have been warranted, in other words, the facts were not such that they were entitled to one by a preponderance of the evidence, that order of protection, if it was in place at that time, regardless of whether it's dismissed, can still be violated, and you can get a order of protection based upon the violation. And we also file violation petitions because we can get a longer order of protection. Generally, the orders of protection are generally for a year. Family courts can go up to 2 years, and it can even be 5 years if it's really serious domestic violence that is occurring. And we certainly ask for longer orders of protections with regard to violations. And the victim can also go into court as the order of protection is expiring to ask for a longer one. It's more difficult to do if there had been no violation between the time that the order of protections was in place and the time it's about to expire. Um, as I said, we also do custody, and custody is basically determined by best interest of the child. Who is in, which parent is in the best interest of the child to go with which parent with regard to custody. Domestic violence must, and this is in the case law, must be discussed and be a factor in the judge's decision. Okay, and there are two ways that, and so here is, as you can see, these are all the different factors that that the judge will decide on. Financial status of the parties, you know, it can sometimes go down to the, there is a factor of, which house is nicer. Do you have sufficient bedrooms for the children? The children are also represented by their own attorney. There's an attorney for the child there in every case, except when, there are babies. And depending upon the age of the child, their wants or desires are taken into effect by the judges. If there is a trial, the judge will have what they call an in camera, and that is an interview with the client just to discuss a whole bunch of factors. They don't necessarily discuss, where or who should have custody. And that is done in chambers with only a stenographer and the attorney for the child. The parents do not hear what the children have to say. It is confidential, and it's left only the other people that know are the judges and the attorney. But as you can imagine, it does sort of come out in the decisions of the judges. And we also deal or have to recognize, the health of the parents, the health of the different children, and their ability to provide with their ability to provide for their children. Obviously, many children have their own issues which need to be dealt with, and we got to make sure that the custodial parent will make sure that those needs are met. There is a preference for keeping siblings together. And as I said, domestic violence is also a factor. And what victims of domestic violence are primarily doing is looking for sole custody. And that means that they make the major decisions with regard to the raising of their children. And when I say major decisions, I'm talking about medical, education, and religion. Okay. You can also have joint custody, and joint custody is sometimes offered to the other side if you want to settle. And joint custody means that the parents must agree to the major decisions with regard to the children, with regard to religion, education, and medical. Regardless of whether it's joint custody or sole custody, it doesn't mean the person with sole custody can pick up and move. And when I say move, I mean, move to Florida, move to North Carolina. That's a whole different other petition. That's a relocation petition. The judges frown upon that because they believe that both parents should be involved in the children's lives. And there's another resolution that we have come up with, and that is joint custody with one parent having final decision making. Now, final decision making, to be blunt, is sole custody. Okay, but what you are doing is you're throwing the other side a bone and saying, you can be have some say with regard to the raising of the child. But if we do that to avoid having a trial, and you do try to avoid trials, because it can be stressful on the litigants, and particularly our client. and you have control over the outcome. Okay, because when we're trying to settle a case, we also have to deal with visitation. And with regard to those abusers who have drug and alcohol problems or anger issues, we want supervised visitation. We want somebody to be there. We want to limit visitation. It could be only a couple hours a week and such. And we generally try to give abusers a path to get off of supervised visitation. And when I mean a path, with regard to drug and alcohol, they have to get drug and alcohol evaluations and follow all recommendations. Be clean. With regard to anger issues, there are parenting classes, there are anger management classes, there are other programs that they can be involved in. And there are some children who don't want to see the other parent at all. And that's where we get into therapeutic visitation. So these are all the issues that we deal with regard to custody. And we try to resolve these cases. Most of them are resolved without a trial, but of course, if they can't be resolved to our client's satisfaction, we have a trial and we let the judge decide. And this process can take a number of months. And also at the Legal Services of Long Island and the Domestic Violence Unit, we also represent people with regard to modification petitions. Modification petition is brought when you have to allege changed circumstances, something in the order you would like to change. And this does happen a lot with regard to parties who don't get along, because kids grow up, their needs change, their wants change, as you get older, the kids are involved in extracurricular activities, they're involved in sports, the older ones are working, and it's very difficult to adhere to a strict visitation schedule. So with regard to parents that are getting along, we do try to put in any orders of custody, other parenting time, as the parties can agree. So you deal with, kids being invited to different parties or going to a family event for one parent when it's the other parent's weekend and such. So we try to inform our clients that yes, they abuse you. Yes, you should be away from them, but the other party is still a parent, and you are sort of tied to them until the child is for the 18th birthday with regard to custody. And it's the same process for starting a petition in court, and a petition, you petition for custody. And as with everything in family court, what you're doing is you're asking the court to do something. With regard to an order of protection, you're asking for an order of protection. With regard to custody, you're asking for custody of the children. And generally, the children have to have lived here for at least 6 months. That's really not possible for newborns. But you do file it in the county where the children live. And at this point, when we're representing the clients, we either assist them in developing their custody petition, or we ask that the advocates help them also. And like I said, there are other petitions that can be filed. The relocation petition, and that is where you want to relocate out of the area. As I said, the courts generally frown upon that. However, there are reasons to do it that the courts will recognize, and one, of course, is that the non-custodial parent is not interested and is rarely seeing the child, isn't participating, and also for financial reasons. And that's the big one, financial reasons. It's expensive to live here on Long Island, and particularly for one person with regard to children. It's and it can be cheaper in other parts of the country. And so if you can find suitable housing and a job in other parts of the country, the courts can and have allowed a parent to relocate with the child. And then we get into all other issues, with regard to parenting time, and we may have to develop a schedule, be it that the non-custodial parent, will have a good part of the summer and or school holidays and such. But as I said, the courts generally like to keep the custodial parent near the non-custodial parent, because even though they might have every other weekend parenting time or dinner in between, when they are near there, they can go to sports events that the children are involved with, school events, plays, concerts, and stuff. And of course, that's limited where they move away. And so that's why the courts generally, want to keep have the children keep a relationship with regard to both parents. And the process with regard to custody is also the same, where we have conference dates. An attorney is appointed to represent the children. The Legal Aid Society represents children and adults. However, the Legal Aid Society won't represent both in a certain case. They'll just have one, and then another attorney will be appointed to assist the courts and represent the different legal needs of the clients. Again, we try to come to a resolution, and if we can't come to a resolution, then we have a trial. And as I said, with regard to the custody decision-making process, and with regard to orders of protection, we try to come to a resolution. We try to come to an agreement. We do not come to an agreement that our client is not in favor of. They're not forced into a stipulation. In fact, if a stipulation, when it is entered, the judges say to the litigants, "Did anyone force or threaten you to enter the stipulation? You're doing it of your own free will," and because they have a right to a trial. They all have a right to a trial. We will represent them at the trial. And at the trial, and we warn our clients, is that you sort of lose control of the custody order. And when I say lose control, I mean the judge is going to make the decision. But if you may be stuck with a visitation schedule that you are not happy with. And some courts, they give the speech, if we have a trial, neither of you are going to be happy with the decision. But, judges try to listen. They try to formulate their decision with regard to both interests of the children. And with the best interest of the children, it's that, both litigants get some parenting time if they want to, and they should have it with their children. Okay, next slide, Sharon. And there are forms that are online for the court systems that the clients can fill out. We will also do it on behalf of clients, and then advocates will also help them. As you see, we have modification forms, and that is after a custody order is in place. A final decision has been made, be it through trial and or agreement. And you bring a modification petition based upon changed circumstances that you want something changed in your order. You can also ask for enforcement. In other words, somebody is denying you parenting time and they're not enforcing the order that's in place. So you bring in an enforcement action, or you can bring a violation petition also. And that's generally brought when one of the parents is not adhering to the schedule. And unfortunately, as we tell our clients, that a parent that doesn't show up for parenting time is not in violation. They are just not exercising their parenting time. So if they don't show up for visitation, they don't take the child when they should, it's not necessarily a violation. What the parent can do is bring a modification petition and cut off the visitation. and say it shouldn't be all this much, it should be a lot less, because the parent with the child is left with the child who's disappointed that they're not seeing their parent. The custodial parent may have made other plans. They have to go to work. They're relying on the other parent to do childcare, but that's not a violation of a court order. But you can bring a modification petition to limit the visitation, and then we also have we can put in certain provisions that if they don't confirm that they're actually going to pick up the child within a certain amount of time, with like a day before, it can be canceled and such. And as with life, people don't always do what they should, and even if there's a parenting schedule, we tell our clients there's no guarantee that they're going to comply with it. If they don't bring the child back, that's an enforcement. That's a violation of a custody order, and then you can bring the appropriate petitions with regard to that. And like I said, we do represent clients with regard to that. All right, Sharon, next slide. Okay, and here is our domestic violence referral form that we're asking all people to use, and we're asking you to send the referral form to either to both myself and Fanny Brooks. She's our paralegal, and myself, and that way if one of us is out, they can we will get it. And particularly with regard to orders of protection, it's done in a expedited form. In other words, we can get an order of protection pro se, and if it's a stay with order of protection and someone's kicked out of the house, the judges will generally give that person the opportunity to come to court within a few days, and there will also be an expedited hearing if the abuser requests one because they are kept out of the house. And I think that sort of concludes my presentation. I didn't do child support, but just so everybody recognizes that we do represent clients with regard to child support. And that's basically done on percentages, 17% for that the non-custodial parent would get based upon the non-custodial parent's income, 25% for 2 kids, and that goes up. And of course, the issues that you're dealing with child support is people try to hide money. People get paid in cash. They don't report all their income. I mean, they are supposed to come in with financial disclosure affidavit, pay stubs, and a tax return. But we deal with all that in support. Does anybody have any questions?
Yeah, so if anyone has any questions, you can put them in the chat. We do have one question, but I did want to address just the referral really quick. So with the referral form, you can definitely use the one that's on the QR code and that I emailed out earlier. But we are creating one that's also a fillable PDF for your ease. So I'm going to send that out also. And then as far as if, let's say a client is not working with an agency, Larry, how would a client get our services?
They can just call into the main numbers. I know, Sharon, you had that up. In Suffolk, because we do have a relationship with Brighter Tomorrows and Retreat, we would send those clients to either one of those domestic violence agencies and get the referral from there. With regard to Nassau, we are accepting clients without a DV agency, but obviously, we like working with advocates. Retreat and Brighter Tomorrows are also referring cases to us in Nassau. We like the domestic violence agencies because they can get counseling, they can get safety planning, they can get a whole bunch of services that are out there, and assistance with regard to housing that we as attorneys are the most experienced it is. But we also deal with the other agencies. It's not to say that we're not going to refer you to other places, but they can call the number in Hempstead and ask to be connected to the domestic violence unit, and either I or somebody from our staff will get back in touch with them.
Thank you. All right, so let's just go. We do have a few questions coming through, so let me just start at the top. So a question from Helen is, are ERPOs available in family court as part of orders of protection? I'm not sure what an ERPO is, but maybe you know.
I believe that's with regard to guns, and that's where the district attorney or the police come in. So that's basically done through criminal. Um, and so that's not something that we're involved with, because that application to grab the guns or such is done in criminal court. Okay. And in order of protection, we can have, and we have put in there that they've got to get rid of all guns and such. But that process that this person's referring to is basically done in criminal court. It's not something that we get involved in.
Okay, thank you. From Grace, if an individual has medical bills related to a DV incident, they have an OP and criminal case filed in court. Is there monetary help available to meet medical expenses for the victim?
Absolutely. It's right in the Family Court Act with regard to orders of protection. You can ask for to be paid in family court, and you would put that in your petition for the order of protection, and there is a provision for that.
Thank you. From Maria, how often does the abuser get custody?
It's rare, and it does happen. And like I said, it's rare because the courts have to recognize that domestic violence is, and to be honest with you, it's basically with regard to housing. A victim of domestic violence has fled the house, they've left, and they've gone to a shelter. And this is the cases that I've had. And the kids don't want to be in the shelter. They would prefer to live with dad. They want to go back. They want to, and the victim did not look for stay away order protection to kick him out of the house, and did not want to go back. And so it does happen because, again, it's the best interest of the child. And unfortunately, the victim couldn't get adequate housing for the children, and the children wanted to go live back with dad. So it's rare, but it does happen. And I suggest to you it happens because of housing.
Also from Maria, did I understand correctly that Brighter Tomorrows is functioning in Nassau County as the Safe Center did?
Not as the Safe Center did. I believe they took over the shelter. So it's doing the shelter, and they are referring cases to us, but they're not providing all the different services that the Safe Center did. I mean, we're providing the legal aspect, but I've been practicing in Suffolk for many years, and and I'm dealing with many DV agencies. The Safe Center for a long time was the only DV agency in Nassau County. So there was a void left when they were no longer functioning. But to answer your question, it's my understanding that Brighter Tomorrows is running the shelter that that Safe Center was running and taking over the actual one. And they are providing court advocacy, and they are providing other services to victims of domestic violence, but not to the level that the Safe Center did. I mean, the Safe Center did divorces, the Safe Center had counseling, and they were involved in a number of different issues dealing with victims of domestic violence and assisting people with other issues. So I don't mean to suggest that Brighter Tomorrows is only doing housing, but I know they took over the shelter.
Thank you. So from Helen, can you talk more about which elder abuse cases you can accept and which you cannot?
We accept all sorts of elder abuse cases. It's and it's in family court. So we need that component, and a family offense that has occurred. So yes, we've done many elder abuse cases. I just did one this week, and I'm not saying one domestic violence case is more sad than the other, but when you're preying on the elderly, it's those are very difficult cases, and but yes, we do that.
Thank you. From Anna, if the parents are tenants and the abused needs to be abuser or abused needs to be removed, is he or she still responsible to pay the rent?
That's the landlord-tenant question, and so the answer is yes, because they're on the lease, and whoever on the lease is responsible for the rent. There is a statute which we have used to get victims of domestic violence off the lease. You do a petition, again, it's a petition in family court, and you say, I'm a victim of domestic violence, I'm on the lease here, and I do not want to be responsible for the rent and whatever other charges that might come up. And so you bring a petition in court, and the courts will get the victim off the lease. So we have done that also.
Yeah. Yeah, I think it's important to remember you can't just, the person can't just leave and expect the landlord to know that what's going on. So you have to be proactive. What happens if the abuser owns the house and there is an OP? Does the victim have to leave the house? What about if there are mutual children?
Oh, no. Abusers who own the house many times will have to leave by way of order protection. It's done frequently, and the severity of the violence is taken into account by the judges. Okay, and so this isn't in the law. It's not in anything. I just seen it in practice. The domestic violence has to be rather severe for a judge to keep an owner of the house out. But it's done a lot. It's done frequently, and you can't just say, I own the house, I have to come in, even though you're committing family crimes, or I'm sorry, committing crimes against your wife, or spouse, and/or children.
If you are a foster, this is from Elena. If you are a foster parent to a child whose father is incarcerated long-term for domestic violence and other issues, TPR is not started yet, even though child is 20 months with foster family and DSS says reunification. This might actually be a question for later. Elena, I think maybe this is a better question to talk off the presentation because it's very specific. So Larry, I'll just send you the question afterwards if that's okay.
Yes, ma'am.
Okay. Are there any other questions? That we can answer? Can roommates go to family court?
Wow. The answer is yes, but it could be dismissed by the fact of there's no family court relationship. And I've seen it go both ways. And to a certain extent, it's the relationship between the two people. Are they commingling funds? Are they do they share a common area and such? So I don't have an exact specific answer for that because it is fact specific and to a certain extent judge specific too. I've seen different judges go different ways on that.
From Juliana, do you, meaning LSLI, help fill out court documents for DV victims who are not clients?
Who are not clients?
Yes, who are not.
No, we only assist people who are clients.
Okay. Any other questions? And like I said, if you do have a question that pops up afterwards, feel free to email me and I'll pass it along to Larry. That's not a problem. All right, so if we don't have any other questions, thank you everyone for coming. And I will send out the slides again. And also, like I said, we're going to create a fillable PDF for the referral form. So it's a little bit easier for you all. And thanks to everyone for coming. And thank you, Larry and his team for being here. And I hope everyone has a great day.
Thank you all.
Thank you.